delay just to.
Okay.
Just for the court to get a file.
Can we stipulate that the officer was in fact a licensed peace officer? Or do you want him to please go through the dog and pony?
I will stipulate to that.
All right.
I've received discovery indicating.
Was he in a police vehicle?
That's correct, Your Honor. Mr. Pryor, you recall that, right?
Yes, Your Honor, he was.
Okay, in a police vehicle. And the arrest was without warrant?
Yes, Your Honor.
All right. I have the following stipulations. It occurred in Bexar County. He was arrested by a San Antonio police officer. The charge was DWI. The event was at 5:34 a.m.
On a Sunday.
Okay, we'll get that. I guess you would stipulate that too, Mr. Edelman.
Yes, sir.
San Antonio police officer is a licensed peace officer. He was in a marked police vehicle. And
yes.
The arrest was warrantless. Therefore, the burden shifts to.
Well, Your Honor, I think that's an improper analysis considering that this is a motion to dismiss for speedy trial.
I agree.
Yeah. I will proceed, Your Honor, if it please support.
It is your motion. Yes, sir.
Yes, Your Honor. Okay.
You're gonna have him testify?
Yes, Your Honor, but first I'd like to show that there was unreasonable delay and that it was uncommonly long as far as the delay is concerned. If the court will take judicial notice, the court had to reset this case 6 times because they had no file on the court. The complaint was not filed until May 13th, 2021. After that, there was already 6 resets, and not because but only because after the arrest, the state still had not filed the complaint and information. So that's more than 15-month delay, which we feel was uncommonly long under the circumstances, and the state has a burden to show as to the reason for such a long delay. Unless the court wants me to proceed with Mr. Pryor testifying as to the prejudice from the delay.
It's your motion. You have to cross your T's and dot your I's before we do anything
Yes, Your
else. All right. First of all, the court takes judicial notice that there was an arrest on November 24th, 2019. Now, question. The complaint is also a part of the record that the complaint was filed on May the 13th of 21. Is that correct? The state disagree with that?
The information was filed on March 5th of 2021, Your Honor, and delivered to the court on March 8th.
Okay, that's correct, Your Honor. The motion for speedy trial was filed on May 13th, 21. So I stand corrected. It was March the 8th, 2021 when the court got the file or the information and the complaint.
All right. You may proceed, Mr. Vargas.
Yes, and the court will take judicial notice that on December 30th, 2019, when this arraignment was set, it had to get reset because there still was no file. Then the second reset was February 25th, 2020, another reset because there still was no file or complainant information. Another reset on May 26, 2020. Again, no file. August 25th, 2020. Again, reset because no file. And I think at some point the court excused the defendant from having to appear. There was no file. December 1st, 2020, still there was no file. March 4th, 2021, still was no file. And I believe the next reset had to be for a jury trial. And when that was set for jury trial, Mr. Endelman indicated that no plea bargains could be made once the case was set for jury trial. So then this case just continued on. And so we feel that this was an unreasonable delay on the part of the state. It was uncommonly long. And there was really no excuse for such a long delay just to get the court's file ready to go. I'd like to swear in Mr. Pryor.
Mr. James Pryor, would you raise your right hand? You solemnly swear that the information and responses you submit to this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Thank you, sir. Mr. Vargas, you may proceed.
Mr. Pryor, you recall that day that you were arrested?
Yes.
At the time, where were you employed?
North Star Energy Solutions.
Okay, and what was your type of work that you do? What was your type of work?
I'm power lineman. Worked on distribution power lines.
And what kind of hours were you working?
The normal hours would be 10 to 12 hours from 7 in the morning to 6:30 at night.
Were you working on Saturday?
Yes.
Okay, and what happened after you got home at 6:30?
I got a call out around 7:30 for a broken pole, and we were working on that from 7:30 at night to about 3:30 in the morning.
All right, and then where were you headed at the time of your arrest?
To go meet my crew for breakfast.
Okay, and you tell the court how your arrest came about?
When I pulled up to the stoplight, I was kind of dozing off as I was driving to go meet my crew, and I fell asleep at the light, just being up all night. And I think as soon as I had stopped at the stoplight, that's when I had dozed off at the wheel and fell asleep.
All right, and then based on that, you were suspected of DWI and there was blood taken. You agreed to having your blood test taken?
Yes.
I pass the witness.
No questions from the state, Your Honor.
I left out some information, Your Honor. May I get back
Proceed.
with
Go ahead.
okay, Mr. Pryor, are you still employed with North Star Energy?
No, I'm not.
Okay, and how about your work crew? Do you still when was the last time you worked for North Star Energy?
Since November of 2020.
Okay, and have you been in touch with any of your crew members since then?
I have not.
Okay, and how about your supervisor who would be able to testify as to your hours and your schedule? Is he still with North Star Energy?
No, he works for Austin Energy now. So foreman.
So, okay. Also, you were released. Were you released on PR bond or on a surety bond?
PR bond?
Okay. And are you still on a surety bond or a PR bond?
It's
A
PR
surety
bond.
bond is where you pay a bondsman.
That'd be the Sherry bond. I paid the bondsman to bail out, and I have to check in every Wednesday, every week.
So to this day, you still have to do that?
Yes.
And did you have a girlfriend at that time also?
Yes.
Are you still with the same girlfriend?
No.
Okay, so you basically broke up, had a
Yes.
breakup with her,
Yes.
and all right. So I passed the witness, Your Honor.
Mr. Edelman, anything?
Yes, Your Honor. Mr. Pryor, when did you and your significant other separate?
I believe it was in 2020. I'd say in the beginning of the year in January.
Thank you. No further questions, Your Honor.
If I may proceed, Your Honor, I present this motion with showing to the court based on the motion that the delay was uncommonly long.
Are you calling a witness, or you're making argument, or what?
No, I have no more witnesses, Your Honor. I've already
All right.
stipulated to the complaint and the evidence, and I rest.
All right. Argument?
Mr. Vargas, I think that's your cue.
Excuse me, I didn't hear that.
I said argument.
Oh, yes. Argument, Your Honor, based on my motion, the delay was uncommonly long, even with COVID. This happened November 24th, 2019. Took until March 8th, 2021 to even get the file to the court. That's over 15 months elapsed. They had all the necessary evidence, the state did, to be able to move forward and on the case. Based on the testimony, his liberties have been restricted to some point as far as having a report to his bondsman, and he has and his motion to dismiss was filed soon after the complaint was filed. The prejudice that Mr. Pryor will suffer on trying to put together this case is the fact that he's no longer employed for North Star Energy, and all the facts and witnesses that we would need to be able to prepare a case in his defense, especially in view of the fact that the discovery we have received so far on the toxicology report that was received on, first one was received on January 10, 2020, for alcohol was 0.003. And then they waited another year till January 11th for a toxicology report, which shows possibly THC in his system. But my understanding was that their whole case was based on the appearance and on the circumstances of my client's arrest. So he's going to be greatly prejudiced in having to move forward for trial in this case. And ask the court to grant my defense motion to dismiss for the violation of the speedy trial right.
Mr. Edelman.
Thank you, Your Honor. As the court is at this point well aware, Barker v. Wingo kicks in when there has been a delay that is presumptively prejudicial, and the typical benchmark is an 8-month delay. Now, that 8-month delay is not a hard and fast rule. It depends on the particular circumstances of the case. More difficult, complex cases will typically take longer to investigate and charge than simpler and easier ones. Nevertheless, the approximately 15-month delay in this case is long enough given the circumstances to trigger the Barker v. Wingo analysis that the court now needs to undergo. And as the court is also well aware, the Barker v. Wingo factors are interrelated, with no single factor being the sine qua non of the court's decision. They vary inversely with one another and in that way are interrelated. And so with that, I'd like to quote from Barker v. Wingo specifically. We have already discussed the third factor, the defendant's responsibility to assert his right. Whether and how a defendant asserts his right is closely related to the other factors we have mentioned. The strength of his efforts will be affected by the length of the delay, to some extent by the reason for the delay, and most particularly by the personal prejudice, which is not always readily identifiable, that he experiences. The more serious the deprivation, the more likely a defendant is to complain. I want to emphasize that, so I'm going to repeat it. The more serious the deprivation, the more likely a defendant is to complain. Now, Mr. Vargas has asked the court to take judicial notice of its file. I would like to ask the court to do the same thing. In particular, I'd like the court to note that since Mr. Vargas was hired to represent Mr. Pryor on November 27th, 2019, there has not been a single assertion of the right to speedy trial. In fact, up until the filing of this motion in, if I'm informed correctly, May 13th of 2021, there hadn't been a single motion of any kind. Now, if the seriousness of the deprivation and the assertion of the right are interrelated in the way that the Supreme Court believes, then the conclusion that a fact finder should draw under these circumstances is that because there has been a complete failure to assert the right to speedy trial until May of this year, that the deprivation, the prejudice experienced by the defendant is necessarily very, very low. If it were higher, then there would be more strenuous efforts to force the state to bring the defendant to trial. I'll continue from Barker v. Wingo. The defendant's assertion of his speedy trial right then is entitled to strong evidentiary weight in determining whether the defendant is being deprived of the right. We emphasize that failure to assert the right will make it difficult for a defendant to prove that he was denied a speedy trial. Now, I'd like to quote a bit from Cantu v. State. If the court would like the citation, I'm happy to give it.
Would you please?
Yes, sir. 253 Southwest 3rd, 273.
Thank you.
Yes, Your Honor. Now, quoting from Cantu, the defendant has no duty to bring himself to trial. That is the state's duty. But a defendant does have the responsibility to assert his right to a speedy trial. Whether and how a defendant asserts this right is closely related to the other three factors because the strength of his efforts will be shaped by them. Cantu then goes on to quote from Barker, the more serious the deprivation, the more likely a defendant is to complain. Continuing, therefore, the defendant's assertion of his speedy trial right or his failure to assert it is entitled to strong evidentiary weight in determining whether the defendant is being deprived of the right. And I want to emphasize this part. Filing for a dismissal instead of a speedy trial will generally weaken a speedy trial claim because it shows a desire to have no trial instead of a speedy one. And now I'd like to bring the court's attention to the crux of defense's motion, which is that it does not ask this court to set this case for a trial at the earliest possible opportunity, considering the delay and asserting the defendant's rights. It asks the court to dismiss the case. There having been no prior assertions of the right whatsoever. So, absent some sort of cogent explanation for why this is the case, the defendant's request for a dismissal of the charging instrument rather than an assertion of his right to trial militates against a finding of the deprivation, because it leads to the conclusion that what the defendant wants fundamentally is to have no trial at all. Quoting again from Cantu, filing for a dismissal instead of a speedy trial will generally weaken a speedy trial claim because it shows a desire to have no trial instead of a speedy one. If a defendant fails to first seek a speedy trial before seeking dismissal of the charges, he should provide cogent reasons for this failure. Repeated requests for a speedy trial weigh heavily in favor of the defendant, while the failure to make such requests supports an inference that the defendant does not really want a trial, he wants only a dismissal. Indeed, the failure to diligently seek a speedy trial supports the hoary lawyer's adage, never tried, never convicted. Now, one might object that a defendant cannot assert his right to a speedy trial until a charging instrument has actually been brought against him. To quote again from Cantu, although one cannot file a motion for speedy trial until formal charges are made, the right to one can be asserted in other ways. The Supreme Court has held that, quote, invocation of the speedy trial provision need not wait indictment, information, or other formal charge. Such is the situation in this case. There are alternative ways that defense could have asserted the right and chose not to. And that failure to do so leads to the conclusion that the prejudice that the defendant now asserts is not as serious as is claimed. Now, defense counsel is correct that the delay caused by the state's failure to file the charging instrument in this case is unusually long. However, that delay is not caused by a deliberate attempt to harm the defense's ability to produce or conduct a proper defense, but was caused by negligence. The failure to perceive that the toxicology report from Texas DPS had been transmitted to our office and that we were ready to produce a charging instrument at an earlier opportunity. As the court is probably well aware at this point, negligent failures are still weighed against the state, but weighed less heavily than deliberate attempts to interfere with the defendant's rights. Finally, I'd like to speak about the claimed prejudice that Mr. Pryor has experienced. He was initially arrested on November 24th of 2019. He did not end his employment with North Star Energy until November of 2020. And so for a year, he was able to remain employed with that organization. There's been no additional evidence that he has been unable to find additional work. Furthermore, when asked if he would be able to locate a manager who was responsible for his work crew at that time, he responded that that manager works for Austin Energy. which implies that that manager can be located and presumably can be produced for testimony if needed. Finally, Mr. Pryor needs to check in with his bondsman every Wednesday. And while I'm sure that that is an irritating inconvenience for which he would like to be free, there has been no evidence that he has sustained any long-term anxiety. There is no evidence that he has required the use of medication to deal with the negative effects of this stressful sequence of events. There is no evidence that he has needed the support of professional counselors or mental health professionals. And so from what I can tell, even considering the delay in this case, the prejudice claimed by the defense is very weak. And so when weighing all of the factors, the defense's failure to assert the right, its assertion not of a right to speedy trial, but of a desire for dismissal, and the evidence of prejudice in this case, I believe that the appropriate response for the court is to deny the motion and to set the case for trial at the earliest possible opportunity.
Mr. Vargas, is that it,
Yes.
Hold on a second. Mr. Edelman, anything else?
Nothing further from the state, Your Honor.
Mr. Vargas?
Your Honor, in response to him, this gentleman's statement that first a motion to for a trial has to be requested, which is very difficult, being that it took 15 months for a court to get a file. Also, I do have under the case of Gonzalez versus the state of Texas, decided on November 20th, 2018, Court of Appeals, 8th District of Texas, and it's also cited on my motion. But it does say, it does go into dictum and does say there are some circumstances in which it may be appropriate for a defendant to file a motion to dismiss rather than a motion for a speedy trial, particularly when so much time has passed that a defendant would no longer be able to effectively obtain a speedy trial, and where defense counsel may legitimately feel that a long delay has caused the client so much prejudice that dismissal is warranted, even if the state is belatedly ready to move promptly on the case. And that's quote from Gonzalez versus State, in which the circumstances were slightly more severe in that it took more than a year to bring that case to trial. And so it was reversed upon her entering a plea, but they went and appealed on the motion for to dismiss. And so I would argue, I would present to the court that under the circumstances my client was under, a motion to dismiss for a violation of the speedy trial right was the appropriate motion to file, as opposed to first demanding a trial, especially where there was no file to be able to even demand a trial. And I asked the court to grant my motion.
Anything else, Mr. Vargas? Anything else, sir?
No, Your Honor.
All right. I'm going to deny the motion under the circumstances. I will allow you an opportunity to file for rehearing at a later date if you so choose, if you develop any further evidence that you want to present to the court.
Yes, Your Honor.
All right. Then that'll take care of this motion at this time.